Exactly behind Justin.
All right. All right, folks, we're going to get started again. So good morning. My name is Aaron Perzanowski. I'm an associate professor here at Western. And I'm really excited to be leading this conversation this morning about international IP exhaustion. We have two great folks joining us this morning. To my left is Ariel Katz, who is associate professor and innovation chair in electronic commerce at the University of Toronto Faculty of Law. And to his left is Guy Rube, who is assistant professor at the Ohio State University Moritz College of Law. So the three of us have all written fairly extensively on this issue of international IP exhaustion. So I'm hoping we'll have a lively conversation this morning. It dawned on me that lots of folks in the room probably are not particularly this notion of IP exhaustion. So I want to start by just giving kind of a really, really brief overview to keep us all on schedule of what this idea is. And then we're going to kind of turn it over and just have a conversation here. So what do I mean by exhaustion? Exhaustion is the notion in intellectual property law that once an IP rights holder, a copyright holder, a patent holder, a trademark holder sells a product to a consumer with respect to that particular product that has been sold, the rights of the IP holder to control the further distribution and use of that product come to an end, and the personal property rights of the consumer sort of kick in at that point. Exhaustion is really important on a practical level, right? It gives us things like used record stores and libraries and eBay and used car lots, things that I think most of us probably value pretty highly. One of the questions that IP law has to address as the markets for these kinds of information goods become increasingly international is the extent to which sales that occur outside of the territorial bounds of a particular nation this exhaustion right in consumers. So for example, does the sale of a college textbook in Thailand permit the owner of that textbook to resell it in the United States, right? So that's the basic fact pattern of a case, Kirtsang versus John Wiley, that the U.S. Supreme Court decided a couple of years ago. The publisher there, John Wiley, says, well, look, we think that exhaustion should be limited to products, to books in this case, that are manufactured within the United States. So this book was made in Thailand, so exhaustion shouldn't apply. The U.S. Supreme Court rejected that view, said that copies made abroad do, in fact, trigger exhaustion. Hopefully I won't be prosecuted for mentioning this fact, but that position is inconsistent with at least the reported position of the USTR when it comes to the TPP negotiation. So we've got an interesting conflict there already. So Kirtsang ostensibly is a case about statutory interpretation, but really the policy questions, I think, are what was really driving the court's opinion there, and I think that's where we want to kind of start this conversation. So kind of my first question for my colleagues here is, let's talk a little bit about the various shapes that exhaustion doctrines can take along this sort of trans-border axis, and what are the reasons that we might favor one rather than the other? Either of you feel free to field that question.
Yeah, I can start. So often the debate on exhaustion is between international exhaustion on the one side, that was the rule that was adopted in Kirtsang eventually, as opposed to national exhaustion, right? That exhaustion applies only to products that are circulated within the country, but importing them can be blocked on grounds of intellectual property. But I think the spectrum is a bit broader because there is also an alternative of no exhaustion at all. And on that spectrum, I think there are only two positions that, in my view make logical sense. And the two positions are either interstellar, intergalactic exhaustion on the one hand that makes coherent sense, or no exhaustion at all. It would be awful, but at least it makes sense logically, and we may get to that later. Anything in between, which could be national exhaustion, or the EU has regional exhaustion. So the EU countries, there is exhaustion, but outside of Europe, you can't import. Those may be kind of sort of political compromise position, but I don't see any coherent, the justification for them, for me, do not make sense. So we may hear a lot, and there are a lot of arguments why IP owners should have the ability to control downstream uses and prevent importation. And there's a lot of some of them make sense, some of them make less sense. But the logic of all those arguments, if you really believe in them, I think leads you to eliminate exhaustion altogether, rather than distinguish between the national and the international.
So what is it about those middle ground positions that you think sort of fails to make logical sense? I mean, what are the criteria we're using to evaluate that?
Okay, so many of the arguments, proponents of weak exhaustion rule or stronger call for IP owners, so there are two types of justifications. One is about price discrimination, the ability of IP owners to divide markets and set different prices for different type of consumers, different consumers with different abilities to pay. Or some problem in their own distribution, need to prevent opportunism among their partners, so they want to limit what they can do downstream. And again, there are a lot of say in favor of those positions, but if you adopt them, then I fail to see why national borders are the relevant criterion, right? If you think owner need control because price discrimination is good because you have rich consumers and poor consumers, and you want to be able to serve both without the poor turning around and selling to the rich, that may be fine, but you have poor and rich within the United States, right? But we're not contemplating eliminating exhaustion within the United States. That's where I see the injunction between the justification for limitation on exhaustion and the relevance of national border. I don't think they are really relevant for that.
Right. Let me jump in, because I'm on record for actually liking the national exhaustion and regional exhaustion rules. And so, yes, it is a compromise. I don't think it's a political compromise. I mean, it might be also a political compromise, but I will defend it not on political grounds, but on substantive grounds. There are different considerations that go into the mix. And when you pull all of them, you can't find a perfect rule will get everything that we want. And within that framework, which I'll explain in a second what I think goes into the mix, or some of the stuff that go into the mix, since sometimes an international border is the point in which we need to draw the line, makes sense as a proxy to other stuff. So Ariel mentioned price discrimination is a big motivation factor in this discussion. The idea is that, let's see the example that Aaron gave, which is a Supreme Court-based example of selling textbook in Thailand. Those textbooks were sold in Thailand for a fraction of their price in the United States. And I would, in some respect, that works great for everybody. The buyers in Thailand get cheap products. The buyer in the United States, of course, would want the cheap products, but they would never get the cheap products because the publisher would never allow sell 30 cents on the dollar books if they can prevent it. So in that respect, we let the rich people pay more, the poor people pay less, and we get this price discrimination, and we get some more money in the pockets of the copyright owners, which is what we are trying to do in intellectual property law. I mean, this is one of the goals of intellectual property law. So that's the price discrimination general argument, exhaustion. Now, for limiting exhaustion. Exhaustion also has benefits. For example, I don't think the rule of no exhaustion makes sense because we want to let people resell stuff. You know, I buy my Toyota and it has patented good, And Toyota want me to be able to sell it because otherwise I won't be able to willing to pay so much for my car if I know that I can't resell it. So Toyota actually wants me, I think, to resell my car because I'm willing to pay more for my car when I know that I can resell it. So there are real advantages to exhaustion. And so if you acknowledge that there are advantages and disadvantages to exhaustion rules, then you have a balancing act. And with that, once you acknowledge that, I think national border makes some sense. It makes some sense. Yes, it's true that buyers in, I don't know, Mississippi and Connecticut might be of different economic standards, so maybe some price discrimination between those two should be considered. But that's not the same gap between buyers in the United States as a whole and buyers in Ireland as a whole. That the gap in the willingness to pay is so big that price discrimination plays a bigger role here. Regional exhaustion is actually, it's a really nice compromise, and I think it's actually a very nice compromise, and I think this is sort of what we need to discuss if you're considering U.S.-Canada border. I think that makes sense. I think in the in the EU, if you buy something in Germany, you can sell it any country, any other country. If you buy it in India or China or the United States for that matter, you can sell it in the EU because then exhaustion doesn't apply. I think it makes sense. It's also encourage people to move between those countries in the region, and when those countries are comparable, I think acknowledging that there is a compromise to be made, I think it's a reasonable. So that's my thing about the advantages of those regimes.
So I want to come back to this point about price discrimination, right? So the Supreme Court in Kirtzang makes really clear that copyright itself does not entail a right to divide markets geographically and engage in price discrimination. So if we take that, if we sort of adopt that position, does that mean that we have to sacrifice price discrimination altogether, or are there other means of achieving? So, you know, if we think that part of the reason we might want to restrain exhaustion is because we think price discrimination is a good thing, I have my doubts about that as a general proposition. But if we believe that, are there other ways of achieving price discrimination that might be somewhat more granular? I mean, national borders are a pretty rough proxy for the kinds of price discrimination that we might be interested in. So are there other alternatives for achieving this result, or does exhaustion just eliminate the ability to price discriminate?
Okay, so first of all, the model why we may like price discrimination, I mean, economists, their consistent position is price discrimination good? It depends, right? So it really depends on the empirical issue in each particular case. Sometimes it may lead to greater output and make all consumers happy, and sometimes it won't. And there is no general answer to that. And you can give an example. I wrote down some example, but I won't go through that, where you show, okay, if you have two countries, the U.S. and India, the profit maximizer here would be with $10, they were $1 there, and then you show how arbitrage ruins and everyone is worse off. But you tweak the numbers a little bit, and suddenly it's the reverse, and you can't generalize at all about that. So the question is, so in a way, the price discrimination and many of the other benefits are sort of a red herring, because the assumption in the debate is that the sine qua non for the good price discrimination that we want is this exhaustion rule. If the IP owners have this legal power to prevent arbitrage, then we get the kind of price discrimination we want. If they don't have it, then they don't have it altogether. But the thing is that they have lots of other means, contractual means, organizational means, to develop different distribution system, and they do it all the time, different types of product, different versions of products, coupons, mail-in rebates. If you don't know, these are forms of price discrimination, right? To distinguish between the people who are willing to have more time to go mail-in rebate to get a few dollars back. You could we think of pharmaceuticals, right? That's a big kind of salient issue, because who wants? It seems very attractive that if patent owners could price discriminate, that would solve the problem of access to pharmaceuticals in developing countries, and who does not want to do that? But governments have the power. They can, national government, they can buy the drugs, or insurers can negotiate lower prices, but those apply only to their insured, but not to others. No, the market is full of ways of implementing various forms of price discrimination without the extra additional, making it illegal to arbitrage or to work around that. And that's the question: do we need this extra legal power? It gives something else, right? It makes the good thing that may be achieved easier to achieve, but there's also many negative downsides, and we should not overlook those. But I'm speaking too much.
No, so what do you think about the alternatives? I mean, do they get the job done?
Sometimes they do. I like price discrimination in the context of IP versus other thing, because in IP I have another goal that sometimes I don't have in other goals, which is to create income to the corporate owner. Fixed cost, which I don't have in other products. Other products go to marginal cost, I'm happy. But intellectual property, I don't want them to drive the prices into marginal cost, because they won't be produced there. So are there alternatives? I think the answer is there are. Are they as good? I'm not sure. And some of those alternatives are take pharmaceutical. I don't sort of care from a policy perspective why I prevent a gray market in pharmaceutical. Right? If I said you cannot buy a drug for HIV for a fraction of the price and bring it back to the United States, if you say you can't do it under FDA law or under any other title or under patent law, it's the same result at the end of the day, which is the law doesn't let you do that. So there are some. So one part of alternative, one section of alternative is legal alternative, which I don't find as dramatically different. Now, are there market alternatives? And the answer is sometimes they are. I'm not sure that they are always as good. Some of them are actually very harmful. So selling a low quality product in developing countries, that's a great alternative, and it's done all the time in non-IP areas, right? I sell just cheap, horrible product in developing country, and I know, well, I just eliminated gray market, because who wants to buy those products in the United States when they know that low quality? I just think exhaustion might give us, national exhaustion might give us better alternatives sometimes. But as a general matter, yes, I think there are alternatives, and we need to evaluate whether they are good or bad compared to.
So I want to come back to this empirical question that you mentioned, right? So the worry is that if we have a true international exhaustion regime, that means we can't engage in price discrimination, which means that one of two things is likely to happen. Either markets in developing countries aren't going to be served at all, or are going to increase dramatically, right? I mean, that's the argument. That's an empirical question, right? It's a worry that I have. I mean, so to put my cards on the table, I've been a pretty strong advocate for very robust international, and as we'll talk about in a few minutes, digital exhaustion rules. But it's not keeping me up at night, but it's a worry, right? So when I read your work and you make this argument, I think if this is true, this is a problem, right? The question is, do we know whether it's true or not? So, I mean, do either of you have a good sense of the answer to that empirical question?
As far as I know, the answer is there a good answer that everybody take 5 economists in the room and they can agree? No. You take them and you find different answers, and it depends on what market you see. I think 5 years after Kirtzing, I think we should have, I don't know if it will be me that will provide the answer, or you, or someone else. Let's hope someone else. But a few years after Kirtzing, someone needs to look at that. And they will need to look at prices, and they will need to look at quality of products, and they will need to look at market share in different countries. And as far as I know, the empirical research is slightly all over the board, and many of it is not IP driven, so which makes it even difficult to take from one area and divide to the other. But you're right, it is an empirical question. I mean, go ahead.
This is when we're talking about physical goods. A parallel importer or parallel exporter always works at a significant cost disadvantage. Because they're not the main distribution system. They don't have guarantee of supply. They have to go and pick their units, and they can't, and they also have to ship from abroad. As and for various other reasons, they operate at a cost disadvantage. It only makes sense for them to do that when there are huge price differences. But it also means that there's always a limit on the size of innovation, right? Because that's one thing.
So Kirtang's actually a great example of that, right? I mean, we're talking about a market where, I don't know how many of you have gone into a college bookstore recently and looked at the prices, but they're obscene, right? I mean, these books cost hundreds of dollars for students in the U.S. They cost, you were talking about like 30%. In some cases, right, it's 10% of the cost of the book outside of the United States. So that massive price discrepancy is part of what justifies the importation in that context, right? So to me, that comes back to this point you made about incentives, right? So we have to be worried in the IP context about the impact that these rules or doctrines might have on incentives for copyright holders. And we are worried that if exhaustion reduces incentives below the point where it still makes economic sense for a publisher to make the product, that we're actually sort of defeating the purpose of IP law. I looked up, based on what public information I could find, which is limited, profitability for John Wiley & Sons, 35% last year. I think they can take a haircut on those margins.
So the year after Kirtan, they lost 35% of their profitability?
No. So their profit margins are 35%.
Okay.
Right? Well above what I think, most companies would be satisfied, right? If it drops to 30% or 25%, are they just going to fold? Are they going to say, we're out of it? This isn't worth getting out of bed in the morning? So, I mean, incentives are important, right? But is it the case that every reduction in incentives is harmful?
Well, at the margin, yes, and I will tell. In all seriousness, if our conclusion is that okay, that's going to be cool. If our conclusion is that John Wiley & Son and in John Wiley & Son business, everybody's got 35%. What are we doing here? Let the three of us form a company and just compete with John Wiley. There's money to be made here, right? Money rolling in that industry. I don't challenge the data. I do know that publishers tell me, and if they must be dishonest, that they are not doing as well and they get pressure and they are working not far above their margins. Now, I didn't check their books.
There's a difference between publishers and academic publishers.
I'm talking about academic publishers, but not John Wiley & Son. And so the argument is this: in a market that is somewhat competitive, and that's an asterisk that we need to unwrap, right? How competitive is that market? Some companies are doing very well, but we can't assume that the industry is doing very well, because if it's doing very well, it will attract more people to come in, assuming that there are no huge barrier to entries. And they will drive that there will be competition among themselves. Now, textbook is a tricky topic, because textbook is one of those areas in which the buyer doesn't make the decision to buy. So there is no competitive measure. When I sign a book to my students, with that, and I try to see what the price is before I sign the book. And let's face it, the book that I've been using for the last 3 years, if they raise prices by 10% next year, I can't, just between us, so shut up. I'm not promising that I will switch, just because that. So what I'm saying, it's a weird market in that respect. But yes, I get your point. Not every decrease in incentive should scare us, but at the margin, we should worry about that in a way.
I wanted to notice it because we could have made exactly the same debate with exactly the same arguments, not about Kirtzeng sending his buddies and family to buy books in Thailand and ship them to Cornell when he was doing his PhD, and that's how he funded his stay in the U.S. But we can think entirely the same debate within the U.S., right? Amazon now has a big business of selling used textbooks, and we can, again, same argument, we should eliminate that, we should prevent that from happening, and that would encourage the publishers to price discriminate between students in the U.S., and all the ability to engage in this arbitrage within the U.S. undermine this ability, and that's why they only price at a very high price, and that reduces the overall amount that they can gather. But if we allow them, if we abolish the first sale doctrine at all, then they would lower the prices. Again, the same argument, which it may be true, it may not be true. And we can also expand similar thing about incentive to many other questions of IP. So why is life plus 70 in the US and not 75 or 80? On the margin, if it would be life plus 80, there may be extra money there, so that may create more incentive. So isn't that a good thing? Maybe, but we don't know, right? At one point we have to make, because we don't really know the empirical answer, and maybe we may never know because they may not be a universal or general. So I think we have to step back and say, okay, what is the role of the state in this in this debate, right? Sellers can try and price discriminate, and usually that's legal. There may be sometimes antitrust issues, but by and large, they can set up, divide markets vertically and have exclusive dealers here and exclusive dealer there, and try to discourage the one from selling into the other. And there are a lot of mechanisms that they can do that, and usually the law allows them to do that. The question is, do we want to add another power to that and say, but if people try that, that's illegal. What do we get from adding this extra layer? Considering that that may entail very long-term costs that the parties who design those systems have no reason to consider, right? And because works that are not exhausted, again, if you think about a copyright that lasts life plus 70 years. So I may want to have the power to price discriminate today about the books that I'm publishing in the next 6 months, and there may be good reasons for doing that. But if my rights are not exhausted, then those books continue to be burdened by kind of basically this kind of easement, right? Other people cannot freely transfer them and donate them and have a yard sale or just put them to the curb and other people pick them, because all of that requires permission from the copyright owner, and you create a huge orphan works problem for could be more than 100 years down the road.
So,
Why?
Speaking of an environment where we might be facing some of these consequences, right, where exhaustion arguably probably does not apply, at least as it is today. So, today we're not just talking about international borders, we're talking about digital borders. And, increasingly the sale of copyrighted works is happening not through the exchange of tangible objects, right, but through the exchange of information. So I want to talk about whether or not our exhaustion rules in one form or another need to kind of make this same transition from the tangible world to the digital world. So what's different about digital markets, and how do those differences kind of play into the answer to that question, I suppose, is the question I have.
Well, I think it's funny that Aaron asked me that question. He's maybe the number one expert in this area in the country, so thank you. So I think when we talk, here's one thing we didn't talk about at all in this discussion, and it cuts across both areas, and that's buyer's expectation. When you are a buyer and you buy something, what do you think that you are buying? Are you buying the right to resell it or not? And I think that's sort of part of the exhaustion discussion that we still didn't touch, and it's applied in the physical world and it applies in the digital world. It was a big consideration in Kirsten. In Kirsten, justice was concerned that buyers wouldn't know what they buy. They go to a yard sale and they pick a book, and now do you need a license or not? A very difficult question if Kirsten would have lost, because so that was a big driving force in Kirsten. And in Kirsten, it's one of the points that, let's make it uniform. And as someone who actually has a lot of sympathy for national exhaustion, I would say that's actually a very good point for international exhaustion. So I don't need to ask those questions as a buyer. What I get is what I get, and I sort of know. Transfer that in the digital case, And in the digital case, I think the same question apply. So generally speaking, the rules are in the United States, based on the recent case law, and some people disagree about what's the current rules, what the law, and not only what the law should be. There is no digital exhaustion right now. The reason is that when you transfer a digital copy from one person to another, you create a new copy. You don't just transfer, and there is a case that says exhaustion is an exception to the right of distribution, not to the right to create new copies. And because you create new copies, exhaustion doesn't apply. That's the case law. And people have written that that's a wrong decision, or we can talk about that, but I think we want to talk about whether it should be the right rule. And it's difficult. The question is, when you buy digital goods, do you know that you are not allowed to resell them? And that's an empirical question that I don't think we have a good answer to, although some people, including Aaron, I know, are looking into that. And so I don't know what the answer. But I'll give you why we might want a different rules. Short answer, why we might want different rules. The argument is that our exhaustion rules are based on the physical character of the goods, in the sense that it is deteriorated over time, in the sense that lending is difficult. It's not as easy to lend stuff from one person to the others. So we have some physical limitation on how much we can share the goods. And because of that, that's part of the decision. So when I'm a publisher, I sell textbooks to you, I know that under lend it to others, but I also know it's difficult for you to do it. So I know that you won't do it so much. When I sell you a digital book, it's very easy to share it. It doesn't deteriorate over time. I can lend it to Aaron now. He can give it back to me in a second. I lend to Ariel in a second. I can do it very, very quickly. So the possibilities of sharing are very, very different, much broader, which means that when I sell that book, my pricing decision is very, very different in the digital context than in the physical context. And maybe I don't want to sell the book if you can share it with 500 people with so much ease. It's opened the door to piracy and non-piracy issues. So it's a different question, I would argue. Partly a different question. But Aaron wrote a lot about that, so you should.
Well, let me give Ariel a chance to weigh in first.
Further about the notice, do consumers know? Okay, so the concern is they assume that they buy something, they assume that they can resell it, and if they don't know, that's a problem. That's a problem, but it's not the only problem. Okay, there's also a huge problem of externality. And again, I'm talking about the long term. So I'm perfectly happy if I'm offered, let's say a publisher tells me, you can buy a book for $100 with all the rights to reuse, resell, do whatever you want, or I give you a discount and I sell it to you for $50 and you cannot resell it. Fully aware that I'm giving away my right to resell, but it can be for me to do that because I think, okay, I'm going to keep the book for maybe a year or 2 or 5 or 10. I do the calculation and I found that in that sense, even if after 10 years I cannot resell it, I get $50 discount today and it's a good bargain for me. So I take this. But what does this mean that I cannot resell the book 10 years down, or I cannot donate it to a library when I die? Right? It means that our cultural heritage, and we're talking about copyright or technological knowledge that's accumulated in things, is in serious danger because all of those things cannot be used, cannot be given away, cannot be tinkered with. Because people, when they made a decision to buy them rationally, even with full disclosure, they decided, I prefer a discount today because I totally discount what I may want to do in the future, and I totally discount what other people, the benefit that they may gain from the ability to read a book, that is 70 years old and nobody really cares about. So all of those externalities are not going to be part of the decisions that buyers and sellers have made today, but they could be enormous externalities on the public, and which is, I agree with the guy now when we think about digital. So digital has a lot of those practical challenges that make things in the short term a bit more complicated, but also think about long terms. and preservation of knowledge, preservation of culture, when when we don't talk about physical paper, but just books that are stored in those devices, and how are those going to be preserved? And even if you're a way of recovery, those old format books from 2005 or something, we're talking about in 2070, even if you have the ability of doing that, you can't do it because you need to find a copyright owner and get permission to use those copies because it involves a production. Then we put our knowledge and cultural heritage in serious danger.
So I want to come back to this point about consumer expectations. So why do we care what consumers expect when they engage in one of these transactions? I think there are a couple of related but different reasons, right? One might be that consumers are confused or deceived, or there's some sort of false advertising going on. And this is an experimental study that I'm working on right now to kind of figure out whether or not when people see the buy now button on Amazon, they actually think they're buying something, and buying something means certain rights that we associate with ownership. So that's one reason we might care. The other reason we care about consumer expectations is because it relates to the problem of information costs. When you have lots of experience buying tangible things, you know what you're getting, right? You don't have to investigate. Less so in the digital environment, right? Especially in a digital environment where rights are determined by contract, by licenses. So each transaction potentially holds the possibility of a different set of rights and obligations, right? So you're spending 99 cents on a song. Are you going to read the license agreement to figure out exactly what you can and can't do with that thing, right? The information costs.
I do it all the time.
You do it all the
Yes,
time.
of course.
The Chief Justice of the United States Supreme Court doesn't do it, as he has been on record saying. And it's not surprising that he doesn't do it. The iTunes license is longer than Hamlet. That's sort of unreasonable, right? Someone did the math and figured out if you take the average amount of time that it takes to read the Java license, and you multiply that by the number of times every day that Java is installed, it leads, I'm not exaggerating here, it leads to 7,000 years of human attention every single day to read that license, right? So my point is that there are worries that come from digital exhaustion, right? But one thing that we get is a certain degree of clarity that I think consumers appreciate and makes the market work a little bit more efficiently. The point you made about lending, I think, is really important. So it might not be the case that we want the exact same set of exhaustion rules, right? Maybe you don't get to do all the same stuff that you did with physical lending. I was just reading your new paper. And so we both had papers that came out on this topic within like a week of each other. And we both independently used the same example about the problem of the lending of digital books and how this could lead to real issues. So that might be one area where we have to kind of scale back and say, look, you might have some rights as a consumer who buys these things, but you don't get all the rights that you used to have in sort of the pre-digital world.
Yeah, but you know, was it Bernard Shaw said we are now haggling on the price, right? We agree on the principle, now we are just fighting on the price, and I wouldn't repeat the original example. You can Google it. One of the nice things about digital exhaustion, I think, one of the very, very, very simplified version of digital exhaustion, I'm not suggesting that that's what you argue for, is look how easy it is to the buyers. We are all used to get physical goods. We presumably maybe know what we are supposed to do with physical goods. Let's treat them the same. So once we pass that stage that no, they are not the same, then all right, then why shouldn't we define a completely new set of? And I fully appreciate the fact that we need to see if buyers understand what they are getting. And I also are completely on board with the way that it's very problematic that what they are getting is not determined by copyright law or by set of rules, but by a contract that no one reads, which is very long and no one reads. But when we go to the question, what should copyright law give them? If you already agree that we need a new set of rights, maybe resale shouldn't be part of that. I don't know, but I take your point that maybe resale should be. I mean, I think it's a tricky question, right?
But couldn't we have a clear distinction between the property rights, namely the copyright, what you can do through copyright, and what you can do with a contract? So again, then it's hard to draw the line, but conceptually, I can think about the lending, again, it's a short-term problem. And I don't feel averse to a notion that about digital lending of books, say, okay, you bought a book, copyright say, yes, you can transfer your rights to someone else, but there's also a contract that says, but you can do it for the next year.
I think the difficulty there practically is that the contract is the device that takes this outside of the realm of copyright law by saying these people aren't owners, right? Yeah. And so if you're not an owner, the copyright rules are not triggered. So I mean, you could imagine a world where that's not the case, right?
So I want to. So the main case is Bob's Merrill, right, from 1908, and the question is there the publisher has a notice on the book and say you can sell it for less than $1.
Yeah.
And everyone who does will sue them for copyright infringement. And the Supreme Court says, no, you don't. You can't do that. And I think we sometimes overlook part of the reasoning, but the one that I'm focusing now is the Supreme Court says Congress, and only Congress can define what copyright is. It gives you the right to distribute, but we say that this does not include, that this right is exhausted. I'm paraphrasing. So this is what copyright gives you, and this is what Congress gives you and what constitutionally could give you. And you cannot by notice define to yourself that somebody who does something contrary to the notice infringes the copyright. You don't have the power to do that. You're not Congress. So even if people have notice, you can't create rights on your own. Now, I think that's absolutely true. That also means that, in my view, and I think unfortunately courts, more recent courts have just overlooked the issue, you can't change the rule by saying, oh, I'm not selling you, I'm licensing it to you.
So I think this is...
Look, they just...
No, they say, yes, you can. No, but they didn't address the Supreme Court said that I don't think they...
So I think we have finally reached a point where the three of us actually agree.
Yes.
Which is wonderful, and maybe a good time to turn things over to all of you for comments or questions. Justin's got his hand up.
And Sam.
Hi, Justin Hughes from Loyola Law School. This was a very interesting discussion. Ariel, you had the most erudite scholarly approach, which therefore strikes me as the most impractical as one who has a foot in both places. And Aaron, you strike me as the person who's forced to live in a society where there's coordination of social activity through the market, and you might prefer something more centralized where we looked at profit margins for everyone and decided what was just. And of course in all this, I probably agree most with Guy. But here's a couple questions, things you didn't talk about that I do find interesting. Is Ariel, Guy's point was that national borders are a rough proxy for price discrimination. I want to galvanize that with something you didn't talk about, and that is distributive justice. Because when we have national exhaustion, then up to the polity, the national body, to determine different redistributive rules for itself to deal with the exhaustion concerns between people at different economic levels. And you know that I'm speaking of libraries or subsidization, or Aaron, on your part, the outrageous price of college books. Well, the college books aren't outrageously priced compared to the tuition costs. And the truth
I don't know if that's a fair comparison.
Right, and the truth is our books probably cost less as a percentage of our tuition than the books cost as a percentage of tuition in France or Canada.
But that's a sign of a different problem.
Right, but the point is that distributive justice issues can be decided by a national government, and you can have national exhaustion, and then they can decide how to compensate across groups for the different prices of books, and that's something that we weren't talking about. The other issue that you guys haven't mentioned at all is the value of national or regional exhaustion is that allowing that type of nation-to-nation price discrimination is an important method for intellectual property owners to fight piracy. And it's not just a question of, Aaron, you said, well, you know, there won't, developing country markets won't be served or prices will go up. Well, when prices go up in developing countries, what goes up also is piracy. And that's obvious. There's obvious reasons for that. So national exhaustion rules and regional exhaustion rules are an important method to allow developing markets to be served by legitimate suppliers. And that's why people through the political, from Jamie Love to me, which is a pretty broad spectrum, favor national exhaustion rules. So I thought if we could talk a little bit about that. And then the last thing I'd like you to Ariel and maybe advocates of international exhaustion is, I think Keith Maskis's work, at least with pharmaceutical prices in the EU, and correct me if I'm wrong because you guys know this better than me, showed that, you know, when there was arbitrage between pharmaceuticals moving from Greece to Sweden, what was happening is it was the middlemen who were taking all the profits. It wasn't the consumers who were getting advantage out of it. And if it is true that middlemen, who are, as Ariel said, undertaking certain risks, get all the profits, then we aren't really doing anything for consumers either. We're just taking the money out of the pocket of the IP owners and putting it in the pocket of other business people, and I'm not sure I see a point to that. So, sorry.
Okay.
I can start. Thank you, Justin. No, you go.
Oh, you want
No,
to
I'm
start?
kidding. I'm just saying. I agree with everything.
Well, just about the middleman, I see the argument, but theoretically it doesn't. If a parallel importer imports, even if it matches the prices at the higher price country, now quantity is larger, supply is larger, prices have to go down. So some of that has to benefit consumers. But I think the EU pharmaceutical question raises another important distinction that I want to make between regulatory arbitrage and market arbitrage. And when I think about regulatory arbitrage, so the simple example, okay, Canada and U.S. both have copyright, different terms, but both have copyright. Pakistan, as far as I know, does not have any copyright law. Okay, so if we decided that we give exclusive right to authors, and I'm an author, I'll publish my book and print my book and sell it here, it probably makes sense to give me the power to prevent people from printing it in Afghanistan and then importing it to Canada or the United States. Because without that, basically we're creating a huge loophole in our regulatory system. And closing this loophole protects the sovereignty, the integrity of a sovereign system to decide what copyright rules we allow. Canada and US now have different copyright terms, right? Canada has life plus 50, US Bad for You adopted life plus 70, made this decision. So think that our public domain in Canada, I think you have copyright owners in the US are entitled to prevent them from coming back to the United States because the US has made a different choice. Pharmaceutical issues in the EU is similar to that because in all EU countries, they regulate the prices of pharmaceuticals. And the reason why Spain and Greece are sources of parallel exportation of pharmaceuticals is because they regulate the prices of a much lower level than than Germany and the UK, the main parallel importers. Now, if UK decided to regulate prices at a higher level than Greece, then I think it makes sense to disallow the importation because then you're not only importing the pharmaceutical, you're basically importing the other regulatory choices of the other country who decided something different from you. And they are allowed to do that, but you're allowed to do something else as a country. But again, the interest here is the sovereign integrity separately rather than integrity of a distribution system of a particular.
Where do you draw the line? It's everywhere, right? If I decide to regulate labor price, that affects the price in the market. So, I mean, you get to national exhaustion from the back door, right there, right? I regulate prices. I regulate the infrastructure in the country. That affects price. And so when you're importing a product from one country to the other, you're importing a lot of string attached to that product. The price of that product is determined by a lot of governmental activity.
But you may have an issue of causality. How much you can attribute the difference in price to a particular difference in a law? When it is, and the importation undermines your ability to choose your own laws differently, I think there is a legitimate grounds for preventing the importation. And we do it with environmental and safety standards precisely for those reasons. But again, that's a legitimate. It's a legitimate goal for a state to do. Protecting the integrity of distribution system is qualitatively an entirely different matter. I think we have not to confuse between the two.
So I want to address quickly a couple points because I know there are other hands. The point about infringement, I mean, I do take that seriously, right? If the inability to price discriminate leads to increased harmful level of copyright infringement, then that's why I think that raising the issue of other means of achieving price discrimination is an important component of this conversation. If there's no other way to do it effectively, then yeah, that should change our outlook on exhaustion. On the profit margins point, look, if rationale for copyright opens the door to inquiring into whether or not we've achieved the optimal level of incentives, right? And a company that is achieving 35% profit margins, to me, is over-incentivized. And I don't see that as a good thing, right? I see that as a source of deadweight loss. And, you know, it's not as though we're faced with a choice of central sort of, Soviet economic planning that I'm advocating, or a pure operation of the market. I mean, copyright law is an interference with the marketplace. And the question is, how big of an interference do we want to create? So I don't see a problem with looking at the level of profitability of these companies in determining on a broad broad level what copyright policy should. I saw some other hands back there.
Sam.
Mhm.
Do you want to give Sam? Oh, he's good.
Yeah, he's got it.
This goes to the question. My name is Sam Trazo from the University of Western Ontario. The question of other means. So there might be really good policy reasons why you would want to restrict the subsequent downstream distribution of goods. And I think, as Justin pointed out really well, there might be distributive justice questions. And maybe it's one thing for the individual consumer to sell it, but if a middleman is going to get involved and start making profit, that seems a little less justified. Why does it have to be copyright law? Why does it have to be intellectual property that is given the task of regulating here? Aren't there other areas of law, business torts, contracts, that would be better suited to sort of try to carry out these policies without the very, very heavy-handed remedies that are available in the case of intellectual property, like business torts, contracts?
So we are very close to being out of time. So if one of you want to address that.
I don't know. For me, it seems like a natural place for international IP law. IP law is a rule designed to keep. In that respect, I agree with Aaron. It is an intervention in the market, and it's not a bug; it's a feature. That's what we do, and for that respect, it seems like a good do it. Can you do it with contract law? To a degree, you can. I'm not sure it will work better. You have all this issue of proving exception through or consent through the stream of commerce. You have other issues, and you have the issue that maybe copyright, what Aaron talked about, maybe copyright is clearer than those boilerplate agreements that maybe I rather if public, if Congress decides it's weird that it made sound, then if producer decides and just stuck it in a bullet pit that no one reads, maybe it's better to have the rules in a clearer way in that way.
Okay.
So I think we're actually out of time. I apologize that you all didn't get a chance to ask your questions, but we're happy to stick around and talk afterwards. So I think we have a break coming up right now for the next.
Yes, a half-hour break before the next panel will begin at 11:30.
That was fun, thanks.